How are we doing? Pre-litigation disputes family. Stephen Palmieri coming to you here today. And today we are going to talk about why does the FCRA call the dispute process a reinvestigation? I mean, where's the original investigation? This is something that I get asked a lot by people. They say, hey, is it a typo in the FCRA? I mean, what gives? Because I can't find in the FCRA where the bureaus or the consumer reporting agencies are required to investigate. So that is a great question, and we are going to go ahead and address that. And also, what does this mean for the consumer's involvement in the whole process of the accuracy of their information? So let's go ahead and jump into it. And as always, if you guys are watching live, feel free to put your comments below. We do these videos for all of y'all, if that is even proper grammar. Okay, let me get this thing pulled up here. We're going to do a share screen. All right. All right, so let's take a look at the FCRA. So first of all, what are we talking about? FCRA 1681I is where your procedures in case of disputed accuracy is. So let's go ahead and open this up first of all and take a look and see. So 1681I is your procedures in case of disputed accuracy. And once again, you're going to find a common theme among my videos that deal with the FCRA, because there's a common theme among the language of the FCRA, which is that procedures is all over the place. Keep in mind, Congress really was shifting this thing from defamation to a procedures-driven statute. Okay, so reinvestigation of disputed information. So 1681I is where that basic cookie cutter credit bureau or consumer reporting agency direct dispute process is spelled out. We don't need to go through this. You can look at it, but basically it says that a consumer reporting agency shall conduct a reasonable reinvestigation. Where is it here? Reasonable. Notice they use the word reasonable, right? Reasonable has to do with your procedures, right? They kind of come together. Reinvestigation to determine whether the disputed information is inaccurate. Okay, so this is important. So when you send a letter to the consumer reporting agencies, they are supposed to re-investigate. So what does this mean? Stephen, where does it say that they're supposed to initially investigate? Well, it is inferred by their duty of accuracy. So if we take a look at 1681E for compliance procedures, let's open that up. 1681E, once again, we have procedures here, right? Procedures. This is dealing with procedures, processes, not necessarily on the face of it accuracy per se, but procedures related to that. Okay, so 1681EB is the one sentence in the FCRA that sets forth the accuracy standard that data is supposed to be reported. And so whenever a consumer reporting agency prepares a consumer report, it will follow reasonable procedures. Okay, again, so it's procedure driven to assure maximum possible accuracy. So what it's really saying is, hey, the credit bureaus are in their business of telling stories about people. If you tell an inaccurate or false story, that's kind of like defamation. And so the credit bureaus, if they're going to be telling stories, they are required to have reasonable procedures to make sure they are not talking smack about the consumer, that what they're saying is truthful. Okay, so let's take a look at this. So if this accuracy standard requires reasonable procedures, well, so procedure has to include something to assure that the information is of maximum possible accuracy. So what is inferred from the combination of these sections right here, reasonable procedures and maximum possible accuracy, is that the only way a consumer reporting agency can reasonably assure maximum accuracy prior to initially inserting the credit into the report, they have to conduct an initial investigation, right? How can you know if something is accurate if you don't investigate it, right? Just like the investigator that, is the prosecutor or whatever. They have to investigate things. Your private investigators, they have to investigate things to uncover the truth, to see what's really going on. Same thing here. So what is inferred from this right here is that the consumer reporting agencies are required to conduct an initial investigation, because that is the only real way that they can have procedures that can reasonably assure maximum possible accuracy. Okay, so that is why the dispute process is referred to as a reinvestigation, because assuming the consumer reporting agencies initially investigated it and it passed their sniff test of maximum possible accuracy, if there are errors, the consumer is putting them on notice, or the consumer's representative, like a CRO, credit repair company, or an attorney, and they are supposed to reinvestigate. Okay, so this is important because, again, I cannot stress enough that we need to focus on the FCRA as a procedures-driven statute, as a procedures-driven requirement, because we know that the liability against the bureaus, the furnishers, and the users of information, which the users are like dealerships, mortgage companies, credit card companies, lenders, their liability is limited for the reporting of inaccurate information. Okay, if we go back to 1681 HE, okay, we're shifting from procedures now back to accuracy. It's important that you guys can understand the difference and the distinction there. Okay, so there is a liability limitation that no consumer may bring any action or proceeding in the nature of defamation, invasion of privacy, or negligence, right? So this is talking about the actual truthfulness of the information. If the information is defamatory, invasive, or negligent, you cannot bring any sort of action against a consumer reporting agency, a furnisher, or a user, okay? Unless that information is deemed to be reported false with malice or willful intent to injure, which is a super high burden, right? So again, what Congress is doing here is they're basically saying, okay, the consumer reporting agencies should initially have reasonable procedures to investigate the information prior to initially inserting it in the consumer report. Once they've investigated it, it passes their sniff test. They insert it in the consumer report. By them doing that, they're implying that it has reached that maximum possible accuracy threshold. Once it has reached that maximum possible accuracy threshold, then assuming that the consumer reporting agencies, the users, and the furnishers are doing what the law requires, well, they should not be reporting false information with malice or willful intent to injure, right? I mean, that is like a super high standard. I mean, it could happen, and it can definitely be argued, but just understand this is a super high standard. So the bureaus are saying, hey, this is in the consumer report. We've already conducted our initial investigation. This thing is maximum possible accuracy. So how can you hold us accountable for defaming you or invading your privacy or being negligent if we did due diligence and what we're saying is truthful, right? Because truth is a defense to defamation, right? Like, I can't be defaming you if what I'm saying is truthful. You may not like it, but sometimes the truth hurts. We've all heard that, right? I think our parents have all told us that. Okay, so once again, the takeaway here is Congress is shifting the liability, so to speak, from the accuracy of the information to the procedures involved in the reporting and the reinvestigation of that information. Okay, so to tie this all together, what does this mean for you, whether you're a consumer watching this, a credit repair organization, or a consumer protection attorney? Well, what this means is that why most people get frustrated with the consumer reporting agencies and believe that they are too big to be brought to justice is because we do not do our due diligence when we set up those disputes. Okay, when we go back to 1681I, procedures in case of disputed accuracy, once again, the consumer reporting agencies are required to conduct a reasonable reinvestigation. So the consumer has no involvement in the initial investigation, right? That is between the consumer reporting agency and the furnisher and whoever else they get the information from. Okay, so the consumer has no involvement in making sure that the information is accurate, right? And people, you see people like they get all angry because they've got bad credit and they're like, when did I ever opt in to this thing? Well, you don't opt in I mean, it's called the First Amendment, freedom of the press, right? You can publish stories about people. It may suck, you may not like it, but if it's truthful, basically have that, right? So they are telling stories about you. The structure of the FCRA basically requires that they assure that the information is maximum accurate. Okay. Then it puts the burden essentially under most circumstances on the consumer at this point. If you are going to trigger the consumer dispute process, I mean, there are certain circumstances a consumer can go straight to an attorney if it's super egregious information, and the attorney can just say, hey, your initial procedures to assure maximum accuracy failed. We didn't even need to dispute this. But in general, the majority of what you're going to deal with is you've got to put them on notice and say, hey, credit bureaus, here's what's wrong with the information, here's why it's wrong, and here's how you need to fix it. Then your letter to the consumer reporting agency triggers their reasonable reinvestigation requirement. So their standard of reasonableness is directly related to what you give them. Because if you just give them a letter that says prove it or remove it, well, that is a super simple letter, right? I mean, they're going to reach out to the furnisher and say, hey, is this Joe Consumers? Furnishers is going to say, yep, shows us it's his, push the verified button, and that's it, right? We're kind of joking here, but not really. That's a super simple example because we can all relate to that versus telling the consumer reporting agencies, why do I have two different balances among the bureaus? Or why do I not have a date of first delinquency? Or why do I not have this? Or whatever your own industry standard of Metro 2 reporting format requires. So their standard of reasonableness is tied directly to the level of detail of the dispute. And so the reason why most people get frustrated, and especially consumer credit repair organizations and consumers, if they talk to attorneys who practice this area of law every day, it's because they're not focused on actually how the FCRA is designed. They're focused on, oh, they didn't verify it or it's inaccurate. Well, why is it inaccurate? Did you give the credit bureaus enough information to reasonably reinvestigate, or did you just kind of send them some vague, ambiguous letter trying to scrub your credit clean? All right. So all this being said here, let's jump into some questions. Hopefully this helps you guys here to understand that the burden is on the consumer to craft a legitimate dispute. Now, if you craft a legitimate dispute, send it over to the consumer reporting agencies. They go ahead and obviously, apparently, seemingly throw it in the garbage can and don't do anything. Well, that is when you argue that their procedures were not reasonable. If you just send them a prove it or remove it letter and they seemingly throw it in the garbage can you really argue that their procedures were unreasonable? So when you hand your file, your letter, your documents off to an FCRA attorney, they're going to want to know, did the procedures of the consumer reporting agency and also the furnisher for the matter, did their procedures fail? If you can keep that in mind as you're putting your disputes together, it's going to help those conversations with your lawyers go a lot smoother. So let's take a look and see here. So let's see, Jeff Bow, you are the best. Well, Jeff, we do this for you. Appreciate you. Super fan, Jeff. And Robert Sigmund, look at that here. Mr. Kredzu, solid information as always. Appreciate that. So again, appreciate all of you for watching, being part of this. Hopefully you can now have a better idea that when you send those disputes off to the consumer reporting agencies, you have the burden to put them on notice of what's wrong. And if you're wanting to hold them accountable, you have the burden of showing them that their procedures were unreasonable. That is the takeaway here. So that being said, like and share this video. Look at that. I'm trying to get rid of you guys. And here we keep going here. What do we have? I have a question. All right. Latoya, I have a question. Do they really do that, or they just match information with other data furnishers? Yeah, so really good question. Okay, so we're talking about what the FCRA requires. It's actually a very good question because now we are talking about procedures, right, Latoya? So yes, their procedures are basically all automated at this point in time. I mean, you do not have like Inspector Gadget, with like the little magnifier lens looking at every, attribute of this client file. So it's a really good question you have. Is they've developed these systems, these processes, these procedures. They've developed an industry standard data format known as the Metro 2 format. At a minimum, their data should conform to their own format. Would we all agree? And a lot of times it doesn't, which is how you tie Metro 2 format directly to accuracy and directly to their reasonable procedures. And so in reality, it's an automated system. There's algorithms, to your point, and it's highly automated. And it's actually a really good point here, Latoya, because if you can understand and people can realize that this is a procedure-driven law, the FCRA is procedure-driven, not accuracy-driven. As weird as that is, I mean, accuracy is the heart of determining why their procedures failed, okay? So you definitely have to have inaccuracies for sure. But the whole design of this thing is to take the liability away from accuracy and place it on whether their procedures failed. So yeah, in reality, you've got this is just an automated system. The furnishers are just pumping information over to the consumer reporting agencies in real time. It goes into their database. And then what happens is it just sits in the database of the consumer reporting agencies until such time that a user of the information, like a dealership mortgage company, submits a credit report request, right? You go to the mortgage company as a consumer, the mortgage company is the user, you fill out a credit application, they submit that application, those details, those identifiers, your name, address, your social, to the CRAs. At that point in time, instantly at that moment, the consumer reporting agency produces your consumer report, right? So until then, the information is just sitting in the database. It is not a consumer report. It is just sitting in the database. Each and every time the consumer report is created, that it's actually a unique creation of a consumer report each and every time, because they have to assemble the data in the database based on the identifiers that are provided to them at that credit application time. Each and every time a consumer report is created, they are supposed to have that reasonable procedure requirement to assure maximum possible accuracy. So they should be combing through and sorting through and investigating the data that they are about to place into that consumer report every time they prepare a consumer report, because each consumer report is a new collection of their data compiled. So good question there. Appreciate that. Again, if you guys like this, go ahead and like and share this. Follow my YouTube channel. And of course, if you really want to dive deep, you can go to creditrepairtrainingcourse.com, where we dive deep and help credit repair organizations understand actually the way things work, so you can take that knowledge and build your dream business. That being said, appreciate you guys for watching, and I will see all of you guys on the next video. You guys take care.